Hello, everyone. Hi. What is a meridian anyway? I don't know. Yeah, guys. I. Sometimes it sets you. Sometimes it sets you up 12 hours early. Sometimes you set it the right way. It's set. Sometimes it sets an hour early. I don't know. Whatever. Yes. Anyways, we got the Richard Allen news. Among many other things, he's filed a motion to suppress, and well, I mean, I think we understand how this is going to go. And we are now 30 days out. So I mean, what's going to happen? I mean, from what we know so far, Judge Gull has done whatever the hell she wants to do. We have learned, we talked about this the last time, jury selection will be conducted in Fort Wayne, and then from there, they will chuck the jury out. The jury is going to go be sequestered out there, and they are going to go through Memorial Day weekend, which I don't understand how they're going to find anybody on a jury wanting to do that, but okay. It just further shows you how fucking stupid I think Judge Gull is. That she's like, nope, you're staying out here. We'll do whatever, and she's gonna do whatever she wants. I always just tries to do a Saturday or two in there because I assume this trial is gonna drag on a lot longer than she thinks is gonna happen. So, I guess we'll start with, I guess the biggest, well, not really big thing, not really surprised, but you guys should see it because we didn't get to touch on it yet, but it was the idea the state had lost 70 days worth of interviews, documents, and just everything related to the case. Well, and that they destroyed exculpatory evidence, or they at least spoliated exculpatory evidence. They hadn't protected it, which you have to do. And that they interviewed tons and tons of people, including Patrick Westfall and all these other Odinist losers out there. Well, Judge Gold did respond to that. And her response, probably a lot of you are thinking, hey, what was the response? Well, a lot what you thought it was going to be. But I want to give to Janet Morgan first for 5. The first dono. Well, thank you, Janet. I appreciate that. So here is where Judge Gold started off once again, not doing an actual judgment entry or an actual ruling. She simply went online to the court and entered minutes onto the docket. Now, this is it. This is the entirety of what she did. This is the entirety of her ruling. She doesn't lay out any laws or findings of fact or conclusions or anything in a way you can rely on. These are just minute entries, and that's all you have. That's all we have from this person. So, what do we have? Well, she did this on the 2nd, so beginning of this month. Having had the motion dismissed for destroying exculpatory evidence from the hearing conducted on March 28th, now denies the motion to dismiss as the defendant has failed to show the evidence was exculpatory. Well, how do you show it's exculpatory if you don't know what's in it? I mean, that's the big thing here, chat. They couldn't show it helped them. How do you show it can help you if you've never had a chance to look at it? What do I know? Judge Gull's a smart. She would probably tell me, "Shut up, fat man! I'm smarter than you." Whoa! And that it was destroyed negligently, intentionally, or in bad faith. Well, I think negligently at the very least. Intentionally, maybe, and then or in bad faith. I mean, I'd argue that intentionally and bad faith are like the same thing, but whatever. Whatever. I mean, negligently is certainly an issue. The recordings of the interviews between February 14th and 20th were lost due to human error or were spontaneously lost due to the equipment resetting. The funny thing is, you don't actually know. So if you don't know, how can you say that it wasn't negligent? I mean, how do you know? If you don't know, how do you know? Francis, honey, how do you know? How do you know? You've made such an assertive conclusion here. How do you know? I don't think you do know. At the time of the interview of Brad Holder was lost, he was not a key suspect in the case. Okay? So what? That doesn't mean he couldn't be one now. That doesn't mean now that the defense has realized he could be a potential third party that committed the crime. No, no, oh, no, 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 no. No, because Judge Gull decided that doesn't count. That doesn't count. Yes, it's a good faith evidence deletion. Yes, yes, that's where she's very nuanced in that way. She's very nuanced in that way. The interview was memorialized in a written report provided to the defendant. How accurate was it? Patrick Westfall was interviewed at his home by FBI agents. That interview was not recorded but was documented in a written report provided to the defendant. Westfall was not a key suspect in the case at the time of the interview. As neither were suspects at the time the interviews were conducted, the defendants failed to show the lost interview was material, and the lack of a recorded interview of Westfall was material. As defendant established materiality to claim a denial of due process, and Alice failed to do so, his rights have not been violated. And that's it. That's all you get. That's all we get. That's the totality of her reasoning. But fucking judges like this, who needs a prosecution? So that is it, and that's her signed order. So there you go. And then we see the state of Indiana subpoenaed the third-party mental health records of Richard Allen. Remember, they tried to do this ex parte. And they're like, oh, we didn't see anything. Well, they filed it again, and guess what? The state of Indiana's motion for leave for court to subpoena third-party records, medical records, is granted without a hearing. You know, where is justice in this world for Richard Allen? Where is the justice? Now, well, we're going to move on from there. We are going to move on from there. And we've got a couple things to look at, Chad. We've got a couple things to look at. And one of the biggest ones I would say at this point is the actually, hold on, which one is this? Let me see here. Which one is this thing we're looking at here? We have the Frank's motions response by the state of Indiana. And this goes through everything that's been filed previously. And I know we touched on it a little bit already, but we need to go back through it. We need to go through it, and then we need to go through Richard Allen's response. So we already know the underlying claims, but we should start with the state's response. So this is the state's response to Richard Allen's third motion for a Frank's hearing. Now comes the state of Indiana by prosecuting attorney and says that the defense, they're the big bads here, Judge. We're the good guys. That the defense has misstated the facts of the motion and would ask the court to deny the motion without a hearing. That's going to happen anyway. Judge Gull doesn't like hearings. I'm surprised she even has a trial and doesn't enter a judgment entry saying on the docket saying, Richard Allen is guilty, rah! And leave it alone. No trial needed. So they start off by pointing out that the defense's third motion for a Franks hearing alleges Tony Liggett failed to include information about geofencing data in the probable cause affidavit for the search warrant for the residence of Richard Allen. Defendants claimed that this warrant was included, the court would not have found probable cause. The defense seemed to claim that the missing information is exculpatory to Richard Allen. However, the information from the geofencing data is mischaracterized and I think he means misinterpreted by the defense. Even if included in the affidavit, the geofencing data would not negate, cancel, and eliminate the facts supported probable cause for the search warrant regarding Allen's residence. Further, the sheriff did not intentionally lie or omit material about evidence. I'm sure he was honest. I'm sure he was honest. Um, the state has outlined the test used in Franks in its two prior responses. In order to have the Franks hearing, the defense's attack on probable cause must be based on deliberate falsehood or acts of reckless disregard for the truth, and those allegations must be accompanied by an offer of proof. The claim should point out specifically the portion of the warrant affidavit that is claimed to be false, and should be accompanied by affidavits or sworn statements reliable statements of witnesses. The defense must show that there is inaccurate or omitted information, and the probable cause lacking if the omitted information is introduced. Specifically, there's three claims. One, Tony Liggett concealed from Judge Diner that at least 3 phones were moving in and around the crime scene at the times when the murders would have been taking place. And the way Lieutenant Jerry Holman memorialized his interview with Turco should cause alarm, but law enforcement chose to include in their reports. Yes, the great Officer Holman, the lying shitbag of Indiana. That Sheriff Liggett failed to make the judge aware of the geofencing data. Let's see. In our case, the defendant is alleging the crime was committed by several individuals involved in Odinism. The defense has filed several motions, theory contained in the motions. The defense continues to promote this theory to the public with no evidence to support the theory. The defense has come to the point where they're making false statements in their motions in a continued effort to support the theory. This is one of those occasions. Okay. The defense claims the data shows 3 phones in the area of the crime scene when the murders occurred. The defense admittedly speculates on a map of the 3 phones as geofencing data that provides evidence of any 3 scenarios. That people are walking around and witness the murders and then identify Richard Allen. That 2, the persons walking around saw nothing and the murders did not happen. Or 3, the persons walking around committed the murders. This, of course, promotes the defense theory. Unfortunately, the defense do not understand how to read or interpret the geofencing data, and once again, I misinterpret the information, and I put misinformation in their motion. Maybe you should have given them to this months and months ago and helped them explain what they're looking at. Not just go, oopsie poopsie, here's extra data. God forbid they don't fucking trust you right now. I'm just saying at this point. The defense was advised on March 4th that the state witnesses specializing in the data would be an ISP, Sergeant Cecil, and an FBI agent, Kevin Horn, or an Indiana State Police Sergeant, Galogza. However, the defense filed their third motion based on newly discovered evidence that was available during the first disclosure in October, and in the second disclosure after counsel was reinstated. The state witnesses for geolocating fencing data would testify that AT&T collects devices to include geolocation data. It's gathered from 3 sources: GPS first, Wi-Fi triangulation second, and cell sites or timing advance. Okay. GPS received can be good to within 3 to 5 meters. Wi-Fi can vary between 15 and 100 meters. And cell sites can range up to several thousand meters. Yep. The cell site or timing advance is inaccurate because the geofencing data estimates where the phone is based on how long it takes to go from tower to tower. Which is funny because they use cell site data to ping people all the time for murders. You could triangulate it. It's not hard. This means the device could be 3 to 15 meters from the pinpoint on the map, up to several thousand meters, depending on the information was collected. Well, you should probably clarify that. When interpreting geolocation data, you can only consider devices somewhere in or near the estimated range. Thus, if an AT&T geolocation and geofence provided a Wi-Fi location with a center point on the Carroll County Courthouse, one could deduct its location as a range of 15 to 100 meters around that center point. If that same center included a cell site or timing advance location of the device, could be a range of 1,000 meters plus. That could include the entire town of Delphi and beyond. So you're saying that, like, the entire town's a suspect now? Ah, thank you for that. Thank you for that. I remember the defense's response, but now you're admitting, like, it could be a lot of fucking people. When a person's a rural area, oftentimes how's GPS not available in a rural setting? And Wi-Fi locations are not available. Therefore, AT&T must resort to cell site location. This is not an accurate way to pinpoint location of a device. See every murder case in the past 30 years. It's actually very accurate. Geofencing does not track movement, so the fact the pinpoint occurs within a certain area is not indicative of the phone moving within that area. That the map defense refers to is actually a geofence data from AT&T. Okay. The points on the map represent GPS longitude, lat, provided as part of a geofence from AT&T. Each latitude, longitude is a point of a range of uncertainty. The point is not where the phone is, it is simply the center of the measurement. So even though the longitude, latitude point is near the crime scene, the actual phone could be more than 5,000 meters away from the point in any direction. Then why would you do this? The data has no date or time associated with them. All information was provided to the defense in a spreadsheet form with discovery. Either they choose to ignore the information or did not understand how to read the information. I'm sure. Okay, so I guess we're never going to see them ever in Carroll County ever use phone triangulation in a murder case ever. The conclusion: the devices were found in or near the murder scene location at the time of the murders, and what geofencing data means an inaccurate evaluation is not supported by analysis by someone with specialized training or knowledge of geofencing data. Well, you could have given them. Remember, you didn't give them the names of the people involved for months and months and months and months on end. Imagine if you would have given them the information of here's who did it. You could talk to them. You didn't give it to them, so they had to make their own conclusions. Yes, they can't read it. They're not experts. You could have told them who the experts were. It took you months to do that. Further, although phones may have a pinpoint on a map that is the area of a crime scene, the actual phone could be several thousand meters away. No geolocation expert assisting the investigation concluded the cell phones were in or around the crime scene when the murders occurred. The defense fails to state how the owners of those phones were interviewed and cleared by investigators. You mean cleared like Westfall and Holder and Elvis and all them? So those guys got cleared too. Whatever, I can't find it. We'll worry about it later. Miss Certainty Leggette's understanding when he signed off on the affidavit. So yes, none of that would cause the judge to deny search warrant. Well, who knows? Who knows? And yes, that's the other brilliant part about this, Luke. They can't get an expert. Judge, can we get an expert? No. How are we supposed to interpret it? That's your problem. Oh well. Yes, who made the map? I know. Who made the map? We don't know. Well, they said AT&T made the map. But even then, remember, these guys were left without months for knowing who did this. Months without who did this. AD says, I love the motion by the almighty Bungholio. Yes, the good faith evidence deletion. Jerrick says you're still streaming. Sean is a machine. Well, thank you. The defense has renewed their request for this type of expert, by the way. Yep, here's the problem, Luke. Remember what I said about the experts. You get the expert, you give him the data. Even if it's going to take him like at least a week or two. And he's got the generate report. That's probably a week. Now you're looking at like 3 weeks down the road, and we're like a week and a half from trial at that point. Guess what happens when you give that to the prosecution? No, judge, this is unfair. Keep it out. These bad men are messing with me. You know what Judge Gull says? You're right. You can't use this. Denied. Judge, can we have a continuance? No. Richard Ella must go to prison now. And that's what's going to happen. That's what's going to happen. So even if they got, sure, but he can cross the state's experts with it. Yeah. But if he's like, well, are you guys going to be able to get him in trial? No. Well, I'm not giving you money just to fuck with the state. That's not how this works. Your man should take it in the ass like a good boy and go to prison. That's how Judge Gold thinks this works. That's how I think Francis Gold thinks this whole thing works. The prosecution's right. They're always right. Philip Martin says, how is this still going on? Does the Indiana Supreme Court not care? Or like the circus they've allowed and encouraged? Oh, I'm sure that some of these justices are aware of what's going on, but they can't stop it. They can't intervene on their own. Stuff has to come to them. So that's all this is. She's just a scumbag, and she's getting away with it. And then we can move on to issue 2. Does Lieutenant Holman's, yes, the great Lieutenant Holman, yes, a man with a hole for an asshole, I'm sure. Just getting pounded out by men at truck stops. Lieutenant Holman there. Lieutenant Glory Holman. Summary of his Professor Turco interview support the defense argument that they gave false information in the search warrant. It's unclear the defense chose to have at least half the content of this Franks motion address events that occurred nearly a year after the submission of the search warrant. It's unclear as to why you guys lied and act like you didn't know who you talked to. But that's another thing. You know, someone's like, oh, I just don't know who I done talked to. I just go around asking questions. I don't take no notes. Yeah, I didn't tell them 2 girls dead, but I don't take no notes in my interviews. I just ask people questions, and I'm just like, I just done ask people. Ooh-wee. Because that was the state's answer for the longest time. We don't know who it was. It was some fancy book learning guy at a college somewhere. Which college? Somewhere in Indiana. Yuck. It fails to meet the burden due to the fact that the Turco interview could have no bearing on what the affidavit contains. However, the defense uses the report to support their assertion in paragraph 34 that law enforcement has attempted to conceal evidence or falsify information in the context of this case. It fails because Lieutenant Holman did not conceal evidence or falsify information. The defense alleges Lieutenant Holman interviewed Turco, then lied about the contents. Lieutenant Holman interviewed Professor Turco on September 23 at the request of the defense following his deposition, where they had revealed that they had been lying about who they talked to. Remember that part. That's the beauty of this. Why did they depose him? Because he had lied about who he had been talking to. And he wouldn't say who he talked to. And then finally they confronted him with the evidence, so he went back and talked to the guy. I know, it's almost like we're kind of fucking lying here by omission. You know, the state would never do that, though. So the deposition, including the inquiry about the investigation of Odinism. Holman advised that a Purdue professor had been consulted by investigators, but he did not participate directly in the inquiry. The defense pressed Holman to re-interview the professor as to his findings and conclusions he didn't interview. Turco's initial report from 2017 clearly states in the introduction, it is not self-evident these markings are runic inscriptions, nor is it immediately clear what they would mean if they were. However, the argument these makings constitute an inscription inspired by Norse runes or modern recreations thereof is quite plausible. Yes. His point is whoever did this is a bunch of fucking idiots. Yes. I'm an Odinist. I'm sure you are, sweetheart. Patrick Westphal, I'm an Odinist. I'm sure you guys hide Odin's spear all night long in the woods. It's not an elephant walk, it's a Norse tradition. The following are conjectures based on the working assumption these lines do in fact constitute a runic or runically inspired inscription. Clearly, Turco was asked to assume the line formations are runes. Holman did not attempt to deceive the reader or leave out key information. However, Holman did another view of Turco to clarify his findings and requested the defense. The defense outlines Lieutenant Holman's summary of that second paragraph in paragraph 18. The defense then outlines what they believe Holman's summary should have stated in his report. The parties held a deposition of Professor Turco on May 21st. At the deposition, Turco stated under oath that paragraph 18 of the defense motion more accurately reflects his opinion by comparison to what was stated in paragraph 22. Paragraph 18 is from Lieutenant Holman's report, while 22 is what the defense believes Professor Turco's report means. It indicates the defense's application of Turco's statements to facts about Brad Holder and Patrick Westphal were not provided to Turco for consideration. Turco stated he was only provided with only a diagram of lines and certain patterns on a blank sheet of paper, which he then replicated and color-coded for reference to this narrative report. Turco went on to state that paragraph 22 does not accurately reflect his opinion at all. Turco stated in his deposition it is not clear that the sticks found on the girls represent Germanic rune script. Really? The professor went on to debunk. He went to debunk. They're all debunked. All the statements that the defense put in their motion, including this is a ritualistic sacrificial killing. So not only is it Bradley and Baldwin and Rosie that are wrong, but Scremin and Labrado are wrong as well. Is that what McClellan's claiming? 4 separate attorneys are just either insane or completely gullible. I don't know. He stated that nowhere in the recorded history of Odinism has a sacrificial killing of children occurred, and if by some slight chance that this is that, it would be the only one in recorded history, and goes against the definition of ritual, since a ritual is something that is done over and over again. The defense outright lied. Oh, they're just maybe they're pretending to be prosecutors. It's a LARP. It's a prosecutor LARP. Maybe that's what they're doing. It's like, I see me in these actions, McClellan says. He's like, they're holding the mirror up to myself. They outright lied to their motion and misrepresented the true findings of Professor Turco. Holman reported the truth in his statement that Turco's findings were inconclusive was correct. The defense statement show is misleading is entirely false. Finally, it is important that the interview of Turco and Lieutenant Holman's narrative summary did not occur until nearly a year after the warrant was executed. Again, defense has not even claimed Turco's findings are an admission from the search warrant affidavit, but rather it is presumably new evidence to support their claim law enforcement is motivated to lie or misstate the truth as part of a conspiracy to protect, hold, or withhold exculpatory evidence to Richard Allen. Yeah, that's what they tend to do. They tend to lie. The threshold to be met for a Franks hearing requires the defense show a substantial preliminary showing of false statements knowing intentionally given or given with reckless disregard for the truth, such that probable cause is lacking for the Richard Allen search warrant. The omissions are included and accuracies are taken out. The Holman narrative and Turco report are not relevant to the warrant affidavit. The defense has routinely put theories and statements in their motions that are not supported by the facts or any real evidence. This is another example of that. The fact the state has a theory of how the crime was committed does not warrant the state to put that in a search warrant. Very true. Very true. But I really can't wait, because I get the feeling Richard Allen's going to get the shaft. And we're going to find out like a year from now, 2 years from now, this was all true. And when people go find McClellan, he's going to be like, "Yuck, I just shucks, folks. Shucks." So, its conclusion. The motion the defense has not met its burden. Nothing more in their beliefs about the geofencing data. Sheriff Liggett did not intentionally or recklessly omit data. The facts in the affidavit are true and accurate and are supported by evidence. There are no material inaccuracies or omissions in the probable cause for search warrant. And the defense argument that law enforcement dishonesty is pervasive and relates back to the affidavit in question is not supported by sworn affidavits or the reliable statements. Yeah, not the fact that they had a cell phone containing video of a guy committing a kidnapping. One of the people they interviewed, and they didn't fucking do anything with it. Yeah, nope. Nicholas Cocksucker. Sure, that's what the C means. McClelland, prosecuting attorney. Put the C in cocksucker. So. McClellan's too busy doing cum tributes on stolen pictures of murdered girls, yes. Oh, this ain't McClellan. The writing is tolerable. Well, these people are doing it on his behalf. He's having his name signed to it, so that's why. Yes, I know it's the new girl who's doing better. She writes a lot better than him. Yep. Oh, we'll get to the Odinism fuckery soon. I know we will. I'm just pointing out. There's like, I'd love to get those Westfall and all these guys and lock them in a room. They'd be like, "No, we really aren't fucking each other in the woods. It really is Odinism." What part of the Odinism includes having gay sex with each other? It's real to us, damn it. It's real. Listen, we're heckin' Odinists. We're like real Vikings, man. Real Vikings didn't have sex with each other. You're lying. They scream. I am not a cob of corn. They would scream as they slowly turn into a cob of corn. All right. So what happened in response? Well, the defense replied. And I will say this much. Both sides. This is the prosecution's response. And then here is the defense's reply to that response. Guys, please justify your alignment straight up and down. Please. Please. For the love of God. Please, just Jesus Christ. That's all I want. Just like straight line. So, anyways, here's where the defense starts. This is going to be a little longer. The one area of agreement with the defense and the prosecution is that in order for a Frank's hearing to be granted, the defense must show there was a falsity done. The affidavit is either intentionally included or included with reckless disregard, such as Leggett's claim that in 2017, Sarah Carball identified the man walking down the 300 North as muddy and bloody and is wearing a blue jacket in order to assist state's timeline when in fact that witness never mentioned the word blood and identified the man's jacket as tan. Because yes, Richard Allen was in the area wearing a blue jacket. This guy wore a tan jacket. So, there's a state lie. Where the defendants must provide a preliminary showing that important information was omitted, such as Liggett's failure to include in the affidavit that Betsy Blair's description of the vehicle at the CPS building was a non-black vehicle that resembled a 1965 Ford Comet, sharp angles which looks at all nothing like Richard Allen's car, as his car was black and was a modern car. Or Liggett's failure to include the description of the person Betsy Blair was on the bridge as being young as 20 years old who had brown poofy hair, which looks nothing like Richard Allen. Or the failure of Liggett to include the fact that Brad Holder had a photograph on his social media that mimicked the crime scene before anyone knew about the crime scene. Among other facts, Liggett omitted in his affidavit. Yeah. Yup. Prosecutors. Uh-oh. 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 The defense would not expect Tony Legend or any law enforcement officer to voluntarily admit that he either intentionally provided false information or omitted information with reckless disregard for the truth. Because the sheriff is not freely to admit that he provided false information or reckless disregard for the truth, the defense has provided through evidence of Franks 1, 2, and Franks 3 throughout the investigation after charges were filed, Wadsworth provided false information or attempted to conceal information. If this court expects or requires that law enforcement admit to intentionally or reckless disregard for the truth, then a Franks hearing is nothing more than a legal fiction, and that's true. Just like just like in Shawshank, when the warden says, what do you expect us to do? Bring him to court?" And he says, "Oh Lord, I did it. Yes, forgive me, God, for being wrong and being lying and wretched and wicked towards Richard Allen." Sheriff Leggett's not going to do that. Neither is Lieutenant Glory Holman. He's not going to come in like, "Yes, I did it. I admit, I lied. I lied and put this poor innocent man in jail. Oh Lord and me." Well, that's not going to happen. We know that's not going to happen. I'm providing evidence to law enforcement and prosecution. The defense is providing the court the opportunity to reach a logical conclusion. If law enforcement in the state of Indiana attempted to conceal information in 2023, then it's reasonable to conclude the law enforcement also concealed evidence, provided false disregard for the truth in the 2022 search warrant. Yes. Remember this, the prosecutor will hammer on witnesses. They're lying. They're liars. Well, the cops have been lying, so they're liars. The defense has provided evidence throughout the history of this case, but particularly in 2023. Laws were under the prosecution have presented false information or attempted to conceal evidence. Again, the purpose of providing said evidence is to provide the court the ability to question law enforcement's intentional or reckless disregard for the truth of 2023 that would cause the court to believe law enforcement would have acted similarly in 2020 when it drafted the search warrant. Yes, people just don't start lying. They tend to have a history of lying. Below is a proposed order granting Frank's hearing, which is intended to assist the court in that it ties many of the defense factual and legal into language that expresses why the court should grant the defense request for Frank's hearing. Even though it's been submitted, we already know this is not going to be granted. Let's just be real. Let's be real. Now comes the court having reviewed the defense their request for a Frank's hearing, and I mean, we know it's not going to happen. As much as we read this, just be ready, guys. I'm not trying to lie to you, but yeah. Anyone seeing people's comments get yeeted? If they're doing that, that's YouTube. That's not me. Mountain Resident says they like the Witcher 3 music and shit. Well, hey, I liked Witcher. Toss a coin to you, Witcher. Oh, Valley of Plenty. I mean, and the show was actually first season was really good till it got to the fucking end with all the weird shit. But Unknown Here says for $2. Oh, I'm gonna come. Don't come. Don't come. So, having reviewed as requested, the court finds and orders as follows. Having watched the 2017 videotape interview of Sarah Carbaugh, and finds that the defense is correct in claiming that in 2017, Sarah Carbaugh never said bloody when describing the clothing of the man. The court also finds the defense was correct in stating Sarah Carbaugh never said the man was observed wearing a blue jacket. In fact, was tan. The court there finds, therefore, Tony Legette provided false information in a search warrant affidavit, and this warrant materially affected the timeline of state of Indiana in advance of its warrants. Additionally, the court, having watched the Betsy Blair videotape statement, having reviewed it, described the man she observed on the bridge as being in his early 20s, having brown, poofy hair. The description does not depict the way Richard Allen looked in 2017. According to age, according to how his wife described, he has always worn his hair very short, almost shaved. Furthermore, Betsy Blair described a vehicle that was not black and furthermore resembled a 65 Mercury. Is it a Mercury Comet or a Ford Comet? Hold on. Board comet. Okay. Oh, it is a Mercury comet. Okay. Was initially okay. The Mercury comet was based on the compact Ford Falcon. Okay. Yeah, but Mercury and Ford are the same thing anyway. Richard Allen's Ford Focus was black and did not resemble a 1965 Ford or Mercury Comet. It does not. You guys know what a Ford Focus is, but if you don't know what a Mercury Comet looks like, here is a Mercury Comet. That does not look like a Ford Focus. Not at all. Although it's funny because it looks like that has an Indiana plate on the bottom. Anyways, that is a Mercury Comet. The court further finds these omitted facts were central necessary. Court finds further Judge Dieter should have known those false and omitted facts that he would have refused to sign are the types of facts a judge would want to know before signing the search warrant. As those show as fact, Richard Allen was not on the bridge, nor was his car parked at the CPS lot, and was therefore not the man that committed the murders. For law enforcement providing false information is not enough to require a Franks hearing. The next step for this court is to determine whether Leggett made these false statements and omissions intentionally or reckless disregard for the truth. The court recognized that Tony is unlike any law enforcement officer will not voluntarily admit he intentionally provided false information. However, in this case, the defense provided evidence by way of police reports, emails, and audios that the defense could show multiple occasions in which law enforcement provided information in 2023 and concealed it. Just a few of the examples are included. The defense provided an August 10th, 2023 deposition of Jerry Holman, in which Holman stated it was not an Odinism or any type of cult worshiping that could have conducted the crime. However, the defense has since provided evidence that Jeffrey Turco never made such a statement. In fact, when asked at his March 21st deposition if Turco ever uttered the words to the police that, based upon his findings, the sticks were not Odinism or any type of cult worshiping, Turco stated that he, falling under oath, that was not a hypothesis that I was asked to weigh in 2017, and certainly would have declined to do so. When comparing Holman's deposition with Turco's deposition, at best, Holman did not provide accurate testimony. At worst, Holman lied. Can you believe that a guy named Jerry Glory Holman would lie? You know, in between taking dicks at a truck stop, lying like that. Would you expect a cop to do that? I wouldn't. In his deposition, Holman explained that based on the Purdue professor's statements, those involved in Odinism were not involved in the crime, and therefore his investigation was essentially abandoned. Holman's statement has never been proven to be false, and that the Purdue professor never claimed it was not Odinism or any type of cult worshipping that could have conducted the crime. That's troubling to the court. It's funny because she's never going to say any of this. I love how they put this together knowing she's not going to grant it. Furthermore, the defense claims that for several weeks following the deposition that the defense had been requesting the identity of the professor as mentioned by Holman. And Leggett essentially redirected the investigation away from Odinism. The defense wanted to conduct a deposition of the professor to confirm the accuracy of the claims made by Glory Holman and Leggett of the Purdue professor's conclusion. The defense made multiple inquiries over the course of August to figure out who this guy was. Each time, the prosecution said he had not been identified. The defense has since provided an email to the court that Prosecutor McClellan sent to the defense on September 6th, in which he claims, as stated above, we are trying to identify the Purdue professor, but no luck yet. Detective Glory Holman has reached out to the FBI, and Purdue has not gotten a response yet. We will continue our endeavors, but we may not be able to identify him/her. However, a report on September 22nd, drafted by Glory Holman and provided to the defense in February 2024, tells a different story and contradicts McClellan's words in early September. In his September report, they didn't get for nearly 6 months, Holman admitted the Purdue police had informed him that the Purdue professor's name might be Turco. Holman knew this information as early as August 12th and no later than August 14th. Furthermore, in Holman's report, he says the following: I notified Prosecutor McClellan I possibly identified the professor. McClellan requested I meet with him and verify he is the one provided the report. This conversation between Glory Holman and McClellan occurred, according to Holman's notes, sometime on or before August 14th. Therefore, McClellan knew for at least 23 days that Holman had possibly identified the Purdue professor as Turco. Yet, despite having this knowledge, McClellan only told the defense that Holman had no luck in identifying the Purdue professor. And I'm sure McClellan's going to say, well, actually, that's true because we hadn't confirmed it yet. That's how he's going to say it. We were lying, technically. Actually, we told the truth. A few days after August 14th, law enforcement received a 2017 report. In the first paragraph, Turco wrote the following: the arguments these markings constituted an inscription inspired by Norse runes is quite plausible, contradicting Holman's sworn testimony. However, said report was not received until the defense made a request to McClellan on October 4th, around 45 days after law enforcement claimed to have received it. Clearly, by September 6th, McClellan had fully been aware for over 3 weeks that Glory Holman had learned of the possible identity of the Purdue professor and had even received the undersigned 2017 report. Yet McClellan claimed to the defense they didn't know. In spite of this knowledge, McClellan refused to alert the defense of the name Turco, nor provide the defense with the 2017 report, but instead told the defense, we may not be able to identify him or her. McClellan, the elected prosecutor, was not forthright with the defense when he told the defense prosecution was not aware of his identity. The court also knows McClellan was a signatory on the search warrant affidavit approving the language contained in the affidavit. The court also concludes that if Nick McClellan was willing to attempt to conceal the identity of the professor, that is logical to conclude that as a signatory approving the language, McClellan might also be willing to fabricate or conceal other evidence in that affidavit. They got to be careful because this is Judge Gull's boyfriend. She's going to say, don't make fun of my man. Oh, I'll put you in contempt. So, it says I was a big fan of Black Yennefer. Yeah. Oh, let's see. The focus and comment are identical. They're making that same platform for years. Well, he had a modern Ford Focus though. That was okay. Hold on here. Where is? Oh, he had a 19. Wait, he had a 65 Focus. I thought they were saying he had a modern car. I thought Alan had like a modern Ford Focus, not a. I was a little confused about the way they word that. Although the Ford Focus, but Patty, I don't get what you're saying because the Focus only been around for like now 25 years. Like the Falcon and the Comet are identical. You might be able to make that argument, but not a Ford Focus. I mean, here's a Ford Falcon, like a Ford Falcon and a. I mean, that's what they're gonna look similar because of the same thing. It's just like a Ford Crown Vic and a Grand Marquis. or a Mercury Marauder, like those are all the same car. But to say a Ford Focus is the same as a fucking Comet is not. Um, Additionally, having listened to Holman's interview of Turco and review the transcript, the court also finds that Gloria Holman's report memorials in that interview is misleading in terms of what Turco actually said. It appears to the court Holman is minimizing Turco's claims that it was a given. The sticks were left behind by someone attempting to replicate Germanic runic script. Gloria Holman's report never mentions the word rune one single time, and it appears that Turco said the claimant's findings were conclusive. In fact, the recordings make it clear Turco never questioned whether those sticks were formed into runes. Turco only questioned the intended interpretation of those runes. Additionally, defense provided on May 1st, McClellan received from law enforcement Todd Click a certified letter and packet containing exculpatory information. Furthermore, the court finds that McClellan did not immediately turn over that exculpatory evidence, but rather waited 4 months before turning it over, and only after depositions were conducted in which the prosecution determined that it was obvious the defense would learn the existence of the exculpatory evidence. 3 law enforcement investigators named Click, Ferenczi, and Murphy believe their investigation revealed evidence that third-party suspects, the Odinism, committed the murders. This is consistent with the defense's theory. The prosecutor's response to the defense claims the defense continued to make up a story. However, the very evidence the prosecution attempted to keep from the defense for over 4 months contains evidence that 3 law enforcement officers involved in the investigation support many, if not most, of the findings and theories of the defense. Law enforcement actually supporting theories of defense is highly unusual, and that is true. It is highly unusual and highly exculpatory. Yes, it is. Very. The prosecution failed to turn over its evidence in a timely manner. Certainly the failure of the prosecutor Ariel's saying, is this normal prosecutor behavior? Pretty much. Pretty much. You have to stay on top of them. They'll hide shit. Yeah, he had a 2016 Ford Focus, which looks nothing at all like that car. Oh, maybe they meant Falcons is in the car the same as the Comet. Yeah, maybe. Certainly the failure of the prosecutor in 2023 immediately provided exculpatory evidence allows this court to draw the logical conclusion that McClellan would be willing to hide evidence from the judge. Yes, it does. It allows that conclusion to be drawn. Furthermore, the defense provided the deposition testimony of Tony Leggett, who swore under oath that he believed the evidence supported that only one man, Richard Allen, committed the crimes, and therefore it could not be a group of Odinists that committed the crimes. However, the defense also provided the deposition of Toby Lazenby, who testified under oath he believed that more than one person was involved in the murders because it would take more than one person to commit the crimes. Yes, it probably would be with multiple victims. Furthermore, Lazenby testified under oath that Leggett in private conversations agreed with Lazenby more than one person was involved. This conflicting deposition by the man who authored the search warrant provides evidence of attempted concealment. It's logical to conclude that he would keep lying in 2023 because he likely was doing it in 2022. It is funny. It is so funny because they want to do this here. This is them. Baldwin and Rosie wrote this, and I know they're like, this is what they want to happen, and this is dreamland. But you write it because you're putting the judge on blast. Like here, they're like, Francis, if you had at all any bit of integrity, you'd be doing it this way instead of being a piece of shit. But you're not, so we'll do what you should do. Um, it appears enough for the court to order a Franks hearing, as at worst it appears that law enforcement or the prosecutor intentionally fabricated and or concealed evidence. Therefore, the court finds the following. So this is what, remember, this is all a proposed order. They find the following: that Tony Leggett, and who approved the search warrant, and Nick McClellan, who approved the warrant affidavit, provided false information. Exactly. That they also provided false information when it came to Betsy Blair. That they routinely hid evidence. As it's logical to conclude if in 2023 they did this, that they likely did this in 2022. Therefore, the court grants the defense request for a Franks hearing and be set at a later date and time. So that's all they're proposed. This is what we'd like you to do, Judge, in our heads. We understand Judge Gull's going to say, "I'm never attacking my boyfriend. Denied." The state of it, and this is back to their actual motion now. State of Indiana has accused the defense of making false statements and continued effort to support the theory those murders were involved in Odinism. Prosecution also indicated its confusion as why Jerry Holman's 2023 attempts, as alleged by defense, to hide the identity and findings of the Purdue professor have anything to do with the search warrant that was filed in October of 2022. The words contained in the proposed order granting a Franks hearing in paragraph 8 should answer the prosecution's questions. That's how Glory Holman's 2023 interview applies on a 2022 search warrant. When factoring the requirements of a Franks request, law enforcement's concealment of evidence in 2023 supports the idea that they were providing false information in 2022. Leggett and Glory Holman are both tenure members of the Unified Command. Unified like a dick in an ass. That's how Glory Holman looks at this. Leggett and Holman are probably unified. That's how they're probably tight like that. McClellan's the prosecutor set up for the search warrant affidavit. All three is shown in paragraphs A through D above, attempt to conceal evidence throughout, or have been found to be accurate, misleading, or false in their statements. As far as the prosecution's claim the defense has made false statements in a continued effort, the defense offers the following. Local rule required the state of Indiana to produce evidence to the defense by December 14th, beginning September 8th, 2023, until October 26th, days before the prosecutor requested the defense get kicked off the case. The prosecutor finally turned over 14 hard drives, several thumb drives, and certain discovery. The court has not yet chastened the prosecution for incredibly late discovery, which the defendant is detailed in previous filings. The state of Indiana's incredibly late discovery, exculpatory, and other important evidence put the defense in a continual bind in terms of preparing this trial and preparing for depositions, while evidence the defense would need for complete deposition preparation. The court has not found the state's failure to follow local rules is either intentional, negligent, or grossly negligent. Even when the defense has provided evidence to the court in Exhibits 1 through 4, the prosecution delayed turning over evidence provided by an investigating officer for more than 4 months. To this date, the prosecutor still has failed to explain this 4-month delay. Again, the evidence, the prosecutor failed to turn on the findings of 3 seasoned investigators, including that worked alongside the FBI. They all supported the theory the Odinists were involved. Theory is not just conjured from imagination. It is a theory supported by multiple officers investigated. Much of the late discovery the state of Indiana turned over was exculpatory in nature, including several interviews the defense had been requesting that were key parts of the Odinism theory that the defense was pursuing, including interviews of Elvis Field, homo, Johnny Messer, homo, Rod Abrams, even bigger homo, along with Westfall and Holder, the Homo 5, the Odinist homosexual 5. Just 5 wieners out in the woods looking to suck each other. Including discovery we're nearly 10 months late was Liberty German's phone dump, including the famous down the hill, down the hill, down the hill. This phone dump contained very interesting information the defense had approximately 1 month to investigate before the prosecutor requested the defense to be kicked off the case. The defense should have had this key piece of evidence to review and provide its experts no later than December 14th. Well, they don't have experts, the court's not allowing them. On or about October 6th, the defense received geofencing evidence. Prosecutor and defense kicked off the case only days after the defense received this evidence. The Indiana Supreme Court reinstated the defense team. The defense team received the geofencing data in form of charts and a map on about January 30th. The defense then took that information to its expert for review. Because the prosecution's late discovery of the geofencing evidence before getting kicked off the case, the defense only had geofencing evidence for 6 days before the court ordered the defense stop working. Again, almost 10 months late after getting back on the case, the defense has now just had over 2 months to analyze the evidence along with what is received. The defense should have had this evidence in December, and they should have. It appears that law enforcement has not written a single report that interprets the geofencing data. And that's the funny part. That's the funny part. They keep talking about, well, there's all this interpretation of it. According to who? There's no report for it. This court has since denied funds for a defense technology expert to conduct further analysis. Attempting to understand the geofencing data, the defense asked for any reports from law enforcement that interpret the data and map the defense located discovery. The prosecutor claims that no reports or notes exist, but the defense can't be sure. Well, how did the defense go? Well, the prosecutor went ahead and got an explanation pretty fucking quick. So something must have happened. In the past, the prosecutor told the defense that no notes existed related to Liberty's phone, only then to be handed them minutes before the deposition began, giving the defense little or no time to incorporate those notes into its deposition preparation. The defense then asked for the names of the geofencing expert the prosecution would call. The prosecution initially refused to identify their expert, claiming it's not his job to provide that information. Yes, listen to that. It's not my job to tell you the name of the expert I'm going to call. It's not my job. And Judge Gull would have said, that's all right, honey. I shall protect you. The prosecutor then stated he would talk to his investigator. Then, rather than simply identify the officer, the prosecutor provided the names of 4 possible experts, but refused to identify which one was their expert that actually analyzed the evidence. Now, apparently in response to his motion, the prosecutor is claiming there are 3 experts he may use, but still has not identified which expert put the map together or gave him the information he used. In response motion, the prosecutor also provides purported information he has apparently obtained from one of 3 officers who apparently has analyzed the data and relied on that information of the prosecutor, thus providing proof the prosecutor has actually known the exact name of the geofencing expert who will be explaining law enforcement's interpretation of the data, but has refused to provide the name of that specific geofencing expert to the defense. Yeah. Rather than simply identifying the proper law enforcement officer to the defense to depose, again, which would be over 10 months late, who put the map together, the prosecutors only narrowed it down to 3 possible candidates. The defense has no way of knowing if anything the prosecutor claims concerning the interpretation of that data is correct because no reports have been provided that substantiate the prosecution's claims in response to the third Frank's motion. Please notice on pages 2 and 3 of response briefs, the prosecution has prevailed to provide the name of a single authoritative report that supports his claims to the accuracy or inaccuracy of the geofencing data, while defense has provided 126 exhibits to back up their claims in Frank's one alone. Apparently, the prosecution simply expects this court to rely on and believe in the prosecution's claims that he, the prosecutor, has asserted on pages 2 or 3 concerning geofencing evidence, well, a single proof that's true. Well, that's what Judge Gull's gonna do. She's gonna say, "Oh, I believe that the prosecution, they're good boys. I sentenced Richard Allen to prison for life." At this time, the state of Indiana has provided the defense a map constructed by someone who shows 3 phones were in an area where the bodies were found moving in and around it, and near a crime scene at the time where the murders would have been committed. Someone took the time to take data and construct that map using only those 3 numbers and not the multiple other phone numbers the data provided. For some reason, the author of that map focused solely on 3 phones. The coordinates provided by the state of Indiana do, in fact, provide the times the phones were in the area, despite claims made by the prosecutor. And that's a very good point. Why just these 3 numbers? Because there were multiple people in the park that day. There were multiple people. So where the fuck? What the fuck? Come on now. In his response motion, the state of Indiana claims the owners of the phones found on the map were interviewed and then dismissed as suspects. The defense is requested to provide any report, video, or document memorializing any or all those videos of the people. The state still has not provided said information or indicated where that information may be found. The first the defense has heard these people were interviewed is in the state of Indiana's response filed on April 3rd. Oh boy. Oh boy, chat. This sounds hyper illegal. Yes, it is. 100% illegal. 100% illegal. Ray says, so when you boil it down, what does the evidence have against him? He admits to being in the area. He admits to having a gun chambered in the caliber of a ejected round of ammunition that was found at the crime scene. And that's it. So that's all they have. That's all they have. Oh. But isn't that beautiful, chat? Well, who did it? Well, who were these people you interviewed? Well, we interviewed them. Can you tell us? No. Why? Because you're the prosecutors. You're bad, man. We told them not to talk to you. Well, can you tell us who they were? No. Why not? Because why? Because we don't want to. And that's what the state is doing right there. Isn't it brilliant? Isn't it fun? It's so funny and so weird. It's so weird and so funny. Just interesting that they do this. Until the defense can depose the correct geofencing expert and analyze the state's expert reports, the defense can only base a conclusion on what the state of Indiana has provided so far. The defense made it very clear in its third notice the defense did not have any reports or information that contradicted its belief the 3 phones were the area of the murders. But the defense could be convinced otherwise once the prosecution gave them the name of the expert. Additionally, because the defense has no further funds for our tech expert, the reliance on prosecution to provide reports and provide the name of the correct expert is even more vital. Should be noted the defense is attempting to raise funds for the variety of experts needed for Richard Allen's defense. It does not know if the tech expert can be afforded even with the money raised so far. Experts are expensive, guys. A lot of money. Even the ones that are cheap. And you don't want to go too cheap because they're not going to be good. Geofencing is a very complicated discipline and requires experts to train the attorneys so it can ask good probing questions that will help the lawyers and the jury understand better geofencing evidence. In his motion, the prosecutor assailed the defense attempts to understand the geofencing data. The defense freely admits they are lawyers and not geofencing experts, and furthermore wish they had the accessibility experts like the prosecution that could be called at no cost and consulted with at a moment's notice. The defense would ask this court to ignore the state of Indiana's unsubstantiated claims and any reports concerning its analysis until the defense had a chance to depose a specific expert that put the map together that the state is still not identified. It's a simple question. Who put the map together? That is the person the defense wants to depose. Yes. Who? Who did this? Because then they can say, why? Explain to us how that works. Why do you have these 3 numbers? Why'd you only focus on these 3 numbers? What does all this mean? I'm not telling you. Well, yeah. The defense implores the this court to review the evidence provided in Franks 1, 2, and 3. Oh, she will. She'll go, denied! Particularly interviews of Betsy Blair and Sarah Carball, compare that information with the affidavit and the search warrant. The defense is also sending the court by overnight mail the following, which the court may not have for purpose of analyzing. The emails from McClellan claiming that Holman still doesn't know the identity of the Purdue professor. Glory Holman's September interview memorializes his interview with Professor Turco, where Glory Holman admits he knew the possibility of the identity as early as August 12th. The transcript of Glory Holman's interview of Turco. The audio tape of Glory Holman's interview with Turco. Turco's report, Turco's deposition. Wherefore, the accused asked in this third Frank's notice and would request the hearing. Signed by Baldwin electronically. Well, we already know what's going to happen. The court, Judge Gull's going to go, denied! Denied! Don't skip on the medical or legal services. Yeah. This reason the defense is speaking to a higher court, not Judge Gull. They are. They already know what Judge Gull's going to do. They already know what she's going to do. Judge Gull's an absolute scumbag. And then McClellan. Once again, people like McClellan and Glory Holman, I'll say it like that, and Limp Dick Liggett, maybe that's his name, Limp Liggett the Limp, and Glory Holman, because, I'm assuming, Liggett got all limp in the glory hole, and Glory Holman's like, what are you doing back there? I can't feel you. He's like, you're not like the men at the truck stop. Oh. These people are a bigger threat to democracy than Al-Qaeda, the Russians, the Chinese, anybody else you can think of out there that are big bads, the globalists. Got the globalists out there, Got the globalists and the lizard people out there at Bohemian Grove. Yeah, they're a big threat to us. But scumbag fucks like these running around your community are a bigger threat to your community, or bigger threat to your safety and way of life. And they got a gun in the cloak of authority. Maps go on walls. Well, a lot of people should go on. A lot of things should go on walls. Violators of the Constitution should go on walls. Ray says, sorry, I was a little behind, but it's ridiculous to be tried. Well, if Richard Allen hadn't talked, here's the thing, guys, and I've said this before. If Richard Allen had not talked to the police, he wouldn't be in jail right now. If he had just kept his fucking mouth shut, none of this would have happened. Richard Allen fucking talked multiple times to the police. Richard Allen literally took this, imagine imagine a man shoving a roll of packing tape just up his ass repeatedly as the plastic's breaking off, and then you've got the little Sharpie end on here, and he just keeps jamming it up his asshole. Then once it's gape, he takes it and just starts spinning it around up inside there. That's what Richard Allen did when he talked to the cops. So, yes, the cops are corrupt, but that's why you don't talk to the cops, because you might be talking to some corrupt cops, and there's no way for you to know until literally you're just sitting in a jail cell with your asshole just falling out all over the floor. You're like, oh, I guess I got fucked in the ass. Whereas if you don't do that, guess what happens? You can't get fucked in the ass. Yeah, it's very philosophical stuff. Very philosophical. He also admits to being in the same clothes as the bridge guy, which is probably their best bit of evidence. Yep. If he hadn't said anything, though, he'd be so much better off. It'd still be a cold case. None of us would ever have known or given a shit about Libby and Abby at that point. Michael Stetson says, gee, Sean, still at it? Kudos to you. Thank you. And those Odinists, they'd be running around in the woods, fucking each other in the ass still, or sucking each other's dicks. Or if they're like, no, we don't do that. We just mutually masturbate. Okay, whatever you have to tell yourself, Odinist. Whatever you have to tell yourself. You are really PPP's grandpa with a starfish posting. Yeah. You gotta stop leaving the sound in the background without headphones on. Making phone calls real weird, Sean. Well, who's that supposed to be? Normally, I know who you've photoshopped me onto. Almost is like Marshall Applewhite from the cult. Carrie says my fantasizing is scurry. Well, but it's clear and it's concise and graphic, so you understand. When you talk to the police, you are literally just shoving your hand into a box and pulling something out and saying, I'm gonna forcibly shove this in my ass." And sometimes it's a piece of jello, and sometimes it's a just broken piece of obsidian, and you basically prolapse your ass out. So think about it like that. It's a great way to look at it because you know what? You won't do that ever then. Just saying. Just saying. I'm just saying. Now we get to the big stuff, chat. Now we get to the big stuff. We got the real now. Here in response to things, here is a notice of discovery provided by the defense. So this is how it works. And I love this because now you can see how real people do this. While McClellan and Glory Holman and Liggett the Limp are doing things, look what Rozzy is doing. Notifies the court that on April 4th, he provided the following in the state of Indiana. An independent neuropsychological evaluation of Richard M. Allen prepared by Dr. Polly Westcott, dated March 31st, 2024. So 4 days later, he provided and it was prepared. He read through it. He looked through it. All right, I'm going to provide this because we're going to use it at trial. And then he says, we may call any and all persons referenced in the above list of discovery as a witness in this case. Cool. So you know what that means? Dr. Polly Westcott may be called as a witness. That's how you do this. This is professional. This right here is how you handle discovery. You don't act like the prosecutor and go, well, I didn't say I wasn't going to call him. Like your fucking Squidward. And then he says, I've served a copy of this by the county e-filing system upon the prosecutor's office and Andrew J. Baldwin, his co-counsel, on the same day. That's how this is done. I do think this is weird in Indiana. You got to put your bar number down below, but okay, cool. Cool. I'm assuming, well, that's a shame if you're there. This guy's got a bar number that's like only 4 digits before the dash. I'm assuming that means he's an old timer, but I don't know. Oh, I didn't share the screen. Oh, I'm sorry, guys. I'm sorry. We'll share the screen. We'll share the screen. We'll share the screen. We'll tamp it up. But here you go. A notice of discovery. We're providing this independent psychological evaluation. And we provided it, and we noticed the court we provided it. And we're also telling you we may call her. Oh, this is how you should be doing it, Nicholas. Listen, don't listen. If Glory Holman and Liggett the Limp are telling you how to do stuff, they're not helping you. Glory Holman's gonna leave. Glory Holman's gonna leave you high and dry. You don't get to go into the bar when you get brought up on misconduct issues. You're like, well, the cop who takes it in the ass told me to go do it. And then the other cop who's got a limp wiener said it was a good idea too. Nope, they're in their own heap of trouble. This is how you do it if you're a professional. This is how you do it. So, that's how you do this. All this ass talk makes me wonder. Well, what do you want me to say? What do you want me to say, Ag? What do you like? What do I attribute all this to? What am I supposed to think? These guys. I mean, this. It's probably what these guys do. It's all in the down low, yo. I'm sure if they had Baldos, they would have they would use them, but they don't have access to that technology yet. They're like Aztecs in the year 14, like Aztecs in the early 1500s. They still haven't figured out how to use the wheel or horses. So now we have other things from Richard Allen that we're bringing up now. There's quite a bit of it. So why am I bringing this up in the order that we're going to look at them? Because they all got filed right at the same time. And the last one is where we start. And hold on here, which oh, wrong. I'm gonna leave that. Hold on, what order do I have these in? And then leave. And then that, and then wait, where's the one I just downloaded? Oh, there we go. All right. So we will now move on to the big stuff from Richard Allen. Odin's Valberto never messes. Yes. Access, they do have corn cobs, though. I'm sure they do. Yes. Berto says, I'm dying from poop poisoning from undercooked shrimp. Oof. Oof, that's rough. That's rough. I've been there, done that. Been there, done that. High Plains Drifter says, can't be bought, can't be beat. High Plains Drifter says, it's coming and I'm bringing it. Hella says, I had a little nap. Well, Hella, would you like to join? I can send you a link. You could join us for a little bit. You're like, I had a little nap. You live on the other side of the world. So, like, it's almost Monday there because it's almost Sunday here. So, oh, where am I going to hold on? Let me see here. Where is oh, by the way, if you guys haven't heard, apparently Israel and Iran we've had kickoff. So Iran basically like bukkakied Israel with a bunch of drones. So we'll see what the reaction is afterwards. But yeah, that apparently happened. So we are going to start off kind of going backwards in the day. So here's where we go. Motion for leave of the court to conduct inmate depositions. Remember, we talked about these inmate depositions are depositions. They're no different than anything else. So they talk about what they want to do, and they want to depose inmates. Their preparation for the jury trial on May 13th. The state in its witness list exhibit list dated March 8th has identified a number of corrections officers and inmates the state intends to call as witnesses in their case. Most, if not all, these inmates are associated with the Westville Correctional Facility, where Allen was housed for over a year before his transfer in December. Yup, he was. And why is this yellow look like piss? I don't like that. There we go. It's a better yellow. There we go. There we go. That's a little bit better. A little bit better. The defense desires to depose one incarcerated individual, Jesse James. Attorney Rosie believes that inmate James currently housed in the Westville Correctional Facility. I'm sure the DOC won't fuck around with this. Westville Correctional Facility is located in a fairly remote area, and Rosie's attempted to secure a location to conduct said depositions in the town of Westville, just a mile or two down the road, but is unable to do so because it's a small town. He did seek out and secure a space at the LaPorte County Sheriff's Department in LaPorte, Indiana, approximately 20 miles away. This is the closest accommodating space to where Rosie was able to secure an adequate space to conduct the depositions. This is really impressive. This Rosie and Baldwin, I mean, this is just, these guys are fucking amazing. How do they do this? I'm thoroughly impressed with the amount of. Now, it does sound like that Rosie had that pull with the sheriff in his county, where he's like, he got his sheriff to agree, yeah, we'll jail Richard Allen here. We're cool with it. They're only like 20 miles away from Delphi. This guy has gone to, um, and here we'll show. Here is a map to show where Westville is inside the state of Indiana. So here we go. Here we go. That's Westville. And this is Gary. This is Chicago. I mean, like, this is the state of Indiana, guys, right here. This is Ohio over here. This is all Indiana. And this is Illinois. This is what we're looking at. But let's figure out how far away these guys are. Because Rosie's in Logansport, Indiana. And you can see Logansport down here. So how far away are they? Directions. Logansport in. Logansport, Indiana. That's an hour and a half away. Okay. And notice that Delphi is down here. So here, well, here is Delphi. Delphi, hold on. Where did Delphi go? Right there. So Richard Allen could have been, here's Delphi. Richard Allen could have been housed here. Instead, they sent him all the way up here, which doesn't make much sense. But hey, whatever. And then the LaPorte County Sheriff's Office. LaPorte County. It's just impressive. They were able to secure all this stuff. Basically, LaPorte County Jail. Okay, that's right there. Cool stuff. Cool beans. Cool beans. I am just, every time I watch what these guys are doing, I'm thoroughly impressed with the amount of work and effort they're able to do for their client, because this is not easy. Calling up this random sheriff's department like, hey, you guys never heard me. Can I secure a spot? This probably took weeks to secure. Rosie respectfully requests his court issue an order regarding his request to conduct depositions of inmate James. Rosie's made arrangements for that depositions occur at the LaPorte County Sheriff's Department on April 18th, commencing at 8 a.m., at which time Rosie desires to depose inmate James. How is he doing all this without, deposing him? Is he, doing a videotape deposition? Because with a court reporter, that's a couple $1,000s. Which I don't think these guys don't have the money for. Rosie requests his court issue an order granting leave of court because they need leave to get this guy, and directing the Indiana Department of Corrections to transport Jesse James to said deposition thereafter and return Jesse James to his respective location afterwards. I get the feeling they're going to get told to fuck off with that. So, objection, Ohio doesn't exist. Well, it does there. I know I'm in for a surprise. Well, we're going to get to that because lo and behold, there actually is an order. There actually is an order, but we'll get to that in a minute. Now, what we did find was from Richard Allen, filed earlier that day. Like I said, we're kind of backtracking. We're not keeping the same cohesive thing in this world. They filed a motion to suppress. So they are suppressing any and all oral and written communication, statements, or admissions during his pretrial detention. In support, Richard Allen was in pretrial detention. It's alleged that he made statements that were that the state of Indiana intends to present to a jury for cause. And it violates Fifth Amendment, Sixth Amendment, his rights under the 14th Amendment, and Article 1, Sections 12, 13, 14 of the Indiana Constitution. The statements were suppressed and retained as a result of psychological and mental coercion illegally directed against the defendant, and were therefore involuntary. And they are asking for it to be suppressed. They conduct a pretrial determining the statements were given involuntary and suppress any communications, confessions, or admissions subsequent to his arrest. Yep. So how do we know this happened? Well, we know this is here because we have a memorandum of law to back it up. Obviously, that's not enough. So they are supporting it with written points. So they pointed that on November 3rd, the Carroll County Sheriff petitioned the court for an order transferring Allen's custody from the Carroll County Sheriff to the Indiana Department of Corrections. On that same day, without the formality of a hearing, Judge Benjamin Diener signed an order transferring Allen's custody to the IDOC without Allen or his legal representatives. At the time, Allen had yet to be appointed counsel. And that's fucked up that he got transported like that without counsel. In fact, Allen's court-appointed defenders did not enter their appearances on November 14th, and therefore Allen had no input in his pretrial detention. The record should reflect the safekeeping order and all exhibits have been personally served on the court in the form of a supplemental index. And we'll go through that index in a second. The record suggests prior to his transfer, Allen may have made a brief stop at the Reception Diagnostic Center where some sort of intake procedure may have taken place, but it does not appear Allen went any formal mental health assessment or testing to establish a baseline in terms of his history or needs. So from approximately November 1st through December of 2023, Allen remained incarcerated in Westville. Allen's attorneys are aware of any pretrial detainee that has ever been housed at Westville in the history of the facility and not the 5 or so years preceding his placement. They point out that the warden was deposed by the defense on March 22nd. He acknowledged he had worked in IDOC for 28 years and was a warden at Westville for 5 years prior. He acknowledged during his entire tenure he was unaware of any other circumstance involving pretrial detention of a man who had been convicted of a crime yet. Yeah, it's completely fucked up that happened like this. We can't do it here. He should be in a different jail. Not in the fucking shoe of a fucking maximum security prison. Allen's attorneys have conducted depositions, watched video from Allen's cell and other video from within the prison, reviewed the records, reviewed Allen's medical records, listened to audio interviews of prison inmates and guards conducted by law enforcement. Through this process, Allen's attorneys have learned that Allen had been accused of making incriminating statements to inmates and guards. Nearly all of these statements occurred between mid-March and June of 2023. During this time frame, there exists medical and psychiatric records suggesting Allen was in a state of psychosis. Allen's defense team has learned Allen was not only detained in an isolation cell in Westville, but prison officials chose to post inmates at Allen's cell door and required the inmates to keep logs of all of Allen's action statements and behaviors. This appears to have occurred during all hours of the day, which this is fucked up. You don't post inmates to observe people. You'll use guards. And even then, why? This appears to have occurred during all hours of the day and continued through the course of much of Allen's stay in Westville. These inmates, all of whom were convicted felons, were not only actively engaged in surveilling Allen's activities, but were also communicating with him. Allen's attorneys have also learned at some point prison officials deliberately pulled the inmates from Allen's cell door and replaced them with prison guards. Allen's attorneys have learned that this appears to have been prompted by an inmate or inmates engaging Allen regarding his pending charges and communicating Allen's thoughts and words to families of these inmates, thereby violating a sense of confidentiality that might exist. I mean, yeah, they're trying. They use the inmates to get plausible deniability because there's no paper trail and nobody's going to believe a bunch of cons. Notably, Allen's living conditions within the prison appear to have been designed, whether intentionally or unintentionally, expose him to some of the harshest conditions that even the most heinous offenders have not endured. This coercive environment was initially the product of Allen being detained in an observation cell used for inmates with suicidal issues. This single cell located in a pod is one of approximately 60 individual seg cells containing felons convicted of crimes such as burglary, robbery, and child molestation and murder. Each one and every one of these inmates had the ability to communicate with Allen by yelling at him at all hours of the day and night, by chastising him every time he removed his cell for purpose of rack showering or other administrative reasons. Allen's attorneys have learned that he was referred to as a baby killer. He was a target of similar accusations during his stay in WCU. Oh, wow, one of the CEOs fucking talked. That's impressive. Prison records reflect that Allen was placed on suicide watch during the majority of his stay, including his initial detention. This occurred despite the fact there were no underlying findings that suggest he was suicidal. Allen's suicidal designation subjected him to even harsher circumstances than other offenders. For example, Allen's bed consisted of a metal plate with a thin mattress, all of which was just a few inches from the concrete floor. Allen was issued an anti-suicide smock, which covers no body better than the garment of a caveman. And you guys have seen those suicide smocks before, but yeah, imagine wearing that for like for months and months and months. I mean, guys, this is what the fuck they're talking about. If you don't know, this is a suicide smock. It's velcroed on. It's like a moving blanket. You can't rip it or tear it. You can't do anything with it. It's like a pair of pants or a shirt. You can't hang yourself with it. That's what Richard Allen was basically made to wear for months. They were going to Epstein him, maybe. So that's what was happening here. Ariel, I know what happened. It kind of ruins if I say, "Oh, it's all going to work out," right? You understand that? Like we're trying to build some suspense here. It's a presentation. It's entertainment a little bit. It's information that needs to be presented in an entertaining manner. Thank you. I hope Richard Allen's made of sterner stuff than Khalif Browder. Yes, I do too. I do too. I understand. It's okay. It's okay. Just saying. The fact they styled the woman's hair like that to advertise the suicide smocks. Well, they're not going to show her with like a bob and like a nice, she's got a nice perm done. So, but yeah, the other guy looks like a crazy guy who wears one. But we're gonna keep going here. We're gonna keep going here. Alan's food was served to him through a cuff portal, and his dining habits involved him sitting in on his bed or on the floor, as his cell was not equipped with a table or chair that otherwise serves a rudimentary dining arrangement. Yes, Alan's cell consisted of a steel toilet and a sink, both direct line of sight of inmates and guards. The toilet bowl is located approximately 24 inches from his bed. Alan's attorneys learned that Alan was not only under constant surveillance, but his lights remained on for many days and nights. It's also true that a suicide watch, he was afforded less or no recreation time and less of an opportunity for showers. In essence, the suicide designation was a cause for the removal of additional privileges to the extent word privilege applies, which in turn furthered a fosterment that led to the deterioration of his physical and mental health. In all, for nearly 13 months, Alan was deprived of any social interaction, no privacy, limited rec time, is left to entertain himself. Alan's intake records indicate that when he got there, he was 5'5" and 175. By the time he left, his weight by April had dropped to 135 pounds. Yeah, prisoners of war get better treatment than this. Unfortunately, Alan's unusual circumstances would extend beyond the door of his cell. Whenever Alan was removed beyond the 12-by-8 steel and concrete box, he was shackled with ankle cuffs, a belly chain, and box cuffs on his hands, and guided around guards with a lead, or what most people refer to as a leash. Yep. As if this restriction on his movement wasn't enough, officials assigned a videographer to Alan to record his movements around the prison, including when he would meet with lawyers. Now, there are prisons and they do have guards with cameras, and that's usually done when somebody is refusing to comply and there's an extraction, because that way they could videotape the entire extraction. And then when that guy tries to sue, they could say, "Look, we used the minimum force necessary, but the guy had a weapon and was throwing shit out of his cell at everybody. So yeah, we bum rushed him with the shield that has a tasers built into it, and we had to beat the fuck out of him because he wouldn't stop fighting." So, but yes, treat him like he's Hannibal fucking Lecter. During all meetings between Alan and his attorneys, he remained shackled, making simple tasks difficult, such as taking a drink from a water bottle. Alan Alan would not be able to communicate as much as a hand gesture during this state. During other meetings, prison officials placed a video camera outside of a window in the visitation room and required Alan to sit on a hard plastic chair in line with the camera, which was less than 10 feet away. Alan's unusual circumstances, even when his wife came. During one visit, Alan was transported outside of the prison to a building reserved for visitation for those inmates of general population. Alan again was shackled and confined during the transport and ultimately re-robed in a green jumpsuit before seeing his wife. He was, however, unshackled during the visit. His embrace with the wife was controlled by prison protocol, which permitted a brief few seconds of contact, despite Alan had not seen his wife for the better part of 6 months. Alan was required to sit on the opposite side of the table from his wife and a two-guard station with an earshot. They were left with absolutely no privacy. The room was completely empty except for his lawyers and a few other guards stationed within the building. This provided no background noise whatsoever, which reminded of some aspect of privacy as he and his wife tried to talk, and his restrictions are not in there. Alan and his wife were also denied the simple concession of getting a drink of water during this visit, despite the fact there were a number of vending machines and a water fountain nearby. Alan's unusual detention involves an even stranger set of circumstances. During the course of their representations, the attorney discovered the existence of dozens and dozens of police reports, audio interviews, and other investigative findings that centered around the Norse pagan faggots. These suspects could consider themselves homosexuals and were referenced in the Franks motion previously filed with this court. The facts and circumstances surrounding the possibility these individuals, known as Odinist, are especially referenced. Allen incorporates herein the details involved in the Franks filings rather than restating the lengthy details. Allen's lawyers also discovered at least 2 guards assigned to his pod and or his movements around the facility held themselves out to be affiliated with the pagan Norse god known as Odin. Yes, they're proud to be homosexuals, I guess. That's great. The guards proudly display their Odinistic beliefs on their own prison uniforms, despite the fact such a display is a direct violation of the policy, which is funny that the warden admits that, and I'm sure nothing happened. And at least one occasion, one of these guards tased Allen after he was placed in a secure cell because Allen refused to move his hands from the cuff port in the door of his cell. A cuff port that is barely large enough through which to slide a meal tray. Allen posed no risk to anyone at the time he was tased. Allen has also battled depression through most of his adult life. He was medicated over the course of his life and, in fact, sought out therapeutic resources to treat and manage his depression. IDOC gave little consideration to his condition at the time, especially given the unusual circumstances in which he was detained. It's also believed that Allen's medications were administered in a less than consistent fashion. Oh, I'm sure. So the issue is whether the state violated Allen's Fifth and Sixth Amendment rights and federal state due process rights by detaining him in solitary in a max security segregation unit while he's awaiting trial. Allen's statements were involuntary and should be suppressed. Yeah. I also argue the Eighth Amendment issue here. The Eighth Amendment issue kind of forces to happen, but I don't know why they're not bringing that up. But course of activities necessary for etiquette defining confession is involuntary within the main due process, and that's Colorado v. Conley, and it's very true. However, coercive police policy activity is not a necessary prerequisite to challenge the voluntariness of a statement under the Indiana Constitution. The proper standard under Indiana law is whether the confession was freely self-determined and the product of a rational intellect and a free will. Thus, courts look to the totality of circumstances when they take into account did the defendant, whether the statement was made under a court order, the use of police trickery, threats or promises by police, the defendant's race, age, or disability, 5, length of detention, 6, physical coercion, or 7, illegal practices. Notwithstanding, it is indisputable Allen's detention were manufactured by the Carroll County Sheriff purposefully without the existence of any sense of due process. The state was never required to establish a burden of proof required by the statute. Allen was then shipped off to WCU and immediately placed on suicide watch at a detention well with no accommodations, not even was afforded up to the other 2,000 inmates housed across the prison yard. Almost simultaneous with Allen's isolation from human contact, prison companions were placed at his doorstep and tasked with the duty of reporting his every move and recording his every word. The companions appear to have gone above and beyond this duty by communicating with Allen about his case and even praying with him as he struggled to understand the rigors of his incarceration. Their mere presence at his doorstep is akin to Messiah of the United States. This is a big one. This is actually one of the ones you learn in criminal procedure. There, the police obtained incriminating statements from a jailhouse informant who engaged the defendant in a conversation and developed a relationship of trust and revealed incriminating information about the charge when counsel was not present. The court held it was improper, and they're asking him to be held the same. The trial court's decision regarding admissibility of a confession or incriminating statement is controlled by determining the totality of circumstances, whether it was given voluntarily rather than adduced through violence, threats, coercion, or other improper influence. Standard indicators for voluntariness include whether the confession was freely self-determined, the product of a rational interest and free will, without compulsion or inducement of any sort, whether the accused's will was overborne. Well, it looks like that happened here. Here, Allen's free will was overcome by the forces of his environment, all of which were placed upon him by the government and its actors. Allen, a man with bona fide pre-existing mental health issues, was detained in an isolation cell, entirely isolated from any sense of meaningful contact, offered up the most basic amenities of life through a cuff port, in his door. He was reduced sleeping on a mattress that was placed on top of a steel plate just above the floor. This mattress and floor doubled as his dining table because he had no accommodations. His attire is reduced to nothing more than a suicide smock covering only a portion of his body. Alan's healthiest accommodations came in the form of recreation that not to exceed 4 hours a week. In this space, there was not enough room to jog or run, only an exercise bike and a pull-up bar. Alan's other accommodation would have been a window slit that was inside the cell. His view of anything outside the boundaries of the penitentiary would have been impaired by the rusty chain link and razor wire. To the extent Alan was ever allowed to be removed from his cell, he was shackled and led around on a leash. All ideal ways to confine and control the movements of a convicted killer or someone who posed a threat to the prison and himself. Alan, at 5'5" and 173 pounds, with not one single criminal conviction on his rap sheet, met none of these conditions. As if this treatment wasn't enough, Alan's forced to endure the intimacies of his restraint system while he was meeting with his court-appointed attorneys inside the confines of the segregation unit. Adding insult to injury, Alan's meetings with attorneys occurred while he had a video camera aimed at his face, recording sessions that should have been afforded the most private environments. And here's the deal. I guarantee his attorney said, "What the fuck are you doing?" And those guys said, "Either this camera's on or you don't have a fucking meeting." I guarantee you they've had to do this and grin and bear it. All this occurred while Alan's medications were being adjusted by the medical team. The combination of factors reduced him to nothing more than a human experiment. Alan's free will was overcome. And they talk about what happens here. They're showing the voluntariness. They talk about the federal courts have a long-standing history regarding the omission of confessions that have been a product of state action that exploits the weak through interrogatory and custodial process. The coercion can be mental as well as physical, and the blood of the accused is not only the hallmark of an inquisition. That if demonstration were needed, the efficiency of the rack and the thumb screw can be matched by more sophisticated modes of persuasion. Prolonged interrogation of accused who is ignorant of his rights and has been cut off from the moral support of friends, relatives is not infrequently an effective technique of terror. That's true. They isolate you. You can break people putting them in seg. That's why they do it. It breaks you. They want to show. They take away the interaction of people, and that can damage you. That's a punishment because they know people need it. Thus, the range of inquiry in this type of case must be broad. This court has insisted that the judgment in each instance be based on consideration of totality of circumstances. Alan's case falls within the parameters. In Blackburn, the defendant had a documented history of mental illness. Having served in the military, which gave him a medical finding he suffered from some form of PTSD. He was in the process of being treated, leading up to the commission of the crime and his apprehension. During an 8 to 10 hour interrogation, Blackburn was given a prepared statement with admissions offered up by him in the course of the interrogation. He ultimately signed the written confession 2 days later. Here, Alan endured a longer, more sustained form of interrogation, one that lasted more than 5 months before he was finally broken. Already suffering from mental health disorder, being cut off from his wife, mother, and daughter, Alan was weak to the point where he slipped into a state of psychosis plagued with grossly disorganized, delusional, paranoid, and highly dysfunctional behavior. These behaviors were manifested through verbal confessations he may have been drugged, verbal confessions to the double homicide, inconsistent with the known facts about the crime scene. That's a big one. If he's talking about things, I did it, and I killed those girls, I fucked them in the ass with a flamethrower. I lit them on fire and I chopped them into pieces. I did it. I fed them in the wood chipper. Well, they're not dead. They're dead, but they're intact. Were they lit on fire? No. They fed in the wood chipper? No. Did he rape them? No. So he's admitting to things that didn't happen. For sleeping for periods, not sleeping for days. Paranoia, stripping off his clothes, drinking toilet water. Covering himself Oh my god, he did cover himself in his own feces and many other socially unacceptable behaviors. Oof. On one occasion, Allen confessed to molesting the two young girls and shooting them in the back. On another occasion, he professes sorrow for molesting Abby, living the others he specifically named. These facts are known to be falsities, none of which are supported by the autopsy findings. As to the cause of the death of the girls, supported by the absence of any evidence, the girls were sexually assaulted near their death. At the time uttered these falsities, the state actors were in the ready position with pen in hand. Those snitches who were being told what to do. Documenting the entirety of Allen's physical deterioration. The infringements didn't stop there. Inmate companions then spread the good word of Allen's confessions to the inmates and the general population, prompting these inmates to share the information with their respective family members and the public. So that's how we learned about Allen's confessing. Proof of these leaks were offered up by the state in the form of audio recorded interviews and accompanying transcripts, including large volumes of the dumps received by the defense in the past. However, Allen neither his legal team were any aware of self-reporting of said leaks by the state to the defense or by the state to the court, despite the fact the state is aware of this information as early as May 12th, when Patton and Elliott were interviewed by law enforcement investigators. Allen due process rights have all been ignored. The truth or the falsity of Allen's statements are no consequence to this analysis. Allen has been treated unlike other pretrial detainees in Indiana in recent history. The methodology employed by the justice system is one of first impression, and therefore, circumstances created by this methodology should not be any part of Allen's guilt or innocence. The system of pretrial detention deployed against Allen runs afoul of the Fifth, Sixth, and Eighth Amendments of the United States Constitution, and Article 1, Section 14 of the Indiana Constitution. For those reasons, this should all be suppressed. Isn't Messiah like a hypo on every bar exam? I mean, it kind of. I mean, it's a very big deal. I mean, here, let's see if I can pull up my notes. So I think I still have them because they all migrated over. Let me see here. Let's go through. Let's find my notes because I still have my notes. Documentos, law school. Crimpro. Remember Crimpro outline? OneNote. Let me see here what we got. There are form fields in a few. Yes. Detect everything. Hmm. Right, hold on here, guys. We're gonna find it. Nope. No, hold on. No. OneNote. Still, highly recommend Microsoft OneNote, you guys. It is some of the best stuff that's available out there. Spring 2020, 2012. Criminal procedure investigation. Yes. Let me see here. Messiah. Where is it? Yeah. Well, Messiah was that he already asked for a lawyer, and that the cops then tried to run around that by having the snitches talk to him. What else is? Where do I have Messiah else? I have it written down in my my notes 3 times. Yeah. Well, and the other part about Messiah, because then it became you have like a Fifth Amendment right to counsel and a Sixth Amendment right to counsel. So that's the Supreme Court ended up going down that road. So that's that's how that goes, and that's the interesting part about when it comes to your um, Fifth and Sixth Amendment rights. I think Gold should be forcibly relocated to a shack in Guyana and forced to live there. I think she should have to go spend a couple of months in the hole. People have no idea how corrupt and evil our government are. That's true. That's true. I'd be shocked if the warden of that prison is not a notist. Oh well, maybe they hold. I bet that prison those prison guards that have the oded stuff on, like the one who's got the oded spear. I mean, it looks like a bullseye for Bukaki. Personally, I'm sure he walks around those little prisoners like, "Hi guys, can we hold each other's spears? We'll be spear carriers for Odin." 15 hours of isolation to start hallucinating for most people. I don't know about that, but it will break you. And Carrie says, "No, it doesn't break you, not if you're trained." Everybody has a breaking point. Everyone breaks at some point. 5 months is impressive he held out. Carrie says for 4.99, "Please learn to meditate and they won't be able to break you." I mean, there are people who've survived for long times, but everyone has a breaking point. Everyone breaks. Nobody's immune. Daryl Brooks is at Supermax with complete segregation. Yeah, and he's already broken. And he'll break even more. Luke is saying, by the way, important thing you skipped over is Indiana requires a show be on a reasonable. Well, hold on here. We'll go back real quick. Um, oh, oh, yeah, here we go. The prosecution only has to prove by preponderance of the evidence the confession was voluntary. So it's not beyond a reasonable doubt because they don't have to do that. It's a preponderance, but I get what you're saying. And there's no way in hell they could meet that. Yeah. Was DNA taken from Libby and Abby? I don't know. That's a shame. Says I got mine if you need it. What wood chipper? Bradley and Rosie deserve the Lawyer Medal of Honor for their work, even if he is convicted. Well, even if he gets convicted, I don't see how the courts overlook what happened here. Yes, she needs to be in a shack on a rock on the sea. Did you see my message that I left tip in the safe house? No, I did not see that. Hold on, let me go take a look real quick. Sorry. But yeah, she Holman and she the Glory Holman and Limp Liggett should all be hanging out in they should all be in a shack on the edge of the ocean. Thank you, Mr. K. That's you're trying on that one. Green caps for $10 over local says love the Richard Allen coverage. Thank you very much. I appreciate that. I appreciate you wanting to do it over there. Thank you so much. Is there some connection between the Odinist in prison and the ones who kill these girls? I don't think so. I mean, these guys are like really far away from each other. They're all just fucking loser shit bags. That's all I'm assuming we can get out of this. Is just they're shitbag losers and I'm an Odinist. I'm sure we could find losers I could find losers here in Ohio are like, I'm a pagan too. Sure you are, honey. Sure you are. And Mr. K says, yes, yes, potentially suicidal. Although that's how I look if you got locked in a cell with this guy. Be like, I've seen things. So I feel like at this point everything black pills me further. Trump trials, Mew. Don't let Mew black pill you. Mew is shit. Mew had a bad case, guys. I know everybody wanted to think Mew was gonna be good, but guys, come on. Be honest with yourself. Mew is bad. Mew was a bad case. Mew was a bad case. especially once we saw the bad stuff. The bad stuff's bad stuff. That tells you how good your case is bad. Yep, Craig Cruden is correct. Even in the military, especially after Korea and Vietnam, we learned everyone breaks. You hold out as long as you can to allow the military to minimize and mitigate the damage your disclosures will cause. Or you disclose things that are not dangerous. Like you could start telling them all the things you know about basic stuff that they might be able to find on Wikipedia. But yes, everyone breaks at some point. Everyone breaks. Carrie says, "You know nothing about meditation." Okay, and you know nothing about interrogation because people will break. They'll break you one way or another. I used to work in a prison, not as a guard. Luke says, "Read the bit right above that." Okay, fine, Luke. But here's the thing: the prosecution only has to prove by preponderance the confession was voluntary. Okay. Under the Indian Constitution, the voluntariness confession must be removed beyond a reasonable doubt. In reviewing the voluntariness, courts look at the totality of it, rather than focusing only the evidence supporting its voluntariness. Okay, you're correct. Under the U.S. Constitution, prosecutors should prove by preponderance the evidence is voluntary. In Ohio, it's only by preponderance as well. So I'm surprised in Indiana, but that's great. Can they prove beyond a reasonable doubt? Here's the thing, though. They're going to get that because you know what Judge Gull's going to say? I believe the state. Think about it. Gull's not going to believe them. She's going to believe them. She's not going to say like, "Oh yeah, I guess you're right." Daryl Brooks broke in court. The dude didn't even make it to prison. Oh, well, he'd been in prison for or jail long enough. He broke, but he was already he Mr. K for $5 dues. He was already mentally broken. He was a mentally broken man. So you can't really break a guy like that. Alan's gonna die in prison. I think he is at this rate. That's a shame for 4.99 says, "Did you know that Sirius Black didn't break while he was locked up Azkaban in Azkaban because he knew he was innocent?" Thank you. Thank you so very much. Thank you. Thank you for that. Thank you for that. Thank you for that Harry Potter lore. Thank you. Damn it. Yes, there's way too many pagans in Yellow Springs, Ohio. Yeah, but that's where Dave Chappelle lives. Sleazy for $5. Thank you, Sleazy. Saying sent you a message Discord if you could take a look. If it's your penis, I don't want to see it. Um yeah, we'll retweet this. Um Also, Sleazy, what have you done to appeal? Because you and me need to talk. We'll talk about what you can do there, okay? I'll talk to you about that, okay? And then we'll go ahead and do something. If you're free tonight, I could talk to you for a couple minutes. Yeah, why does the other guy look like Nick Storrow? Looks like I sent you receipts. Why you can't? I understand. I read it. You agree? Yeah, 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 yeah. Fine. Even under preponderance standard, I don't think the state can meet it. Carrie says, "You have never meditated. You have no clue what I've lived, Sean." I have meditated, and I don't know what you've lived. An appellate review is basically abuse of discretion. You know, like I said, the courts are going to figure out a way to punt on everything they can. Luke is saying they just need substantial evidence supporting involuntariness for the appellate court to uphold the finding. They will determine that beyond a reasonable doubt for them is the preponderance standard. That's what they're gonna do. They'll see it meets preponderance level, and they'll say, "For us, it actually counts good enough." Um, where are you guys at right now? I'm all free all night, okay. Yes, thank you. I need more Harry Potter facts in my life. Petty saying, "Oh, World War III for our greatest ally can't stop me." Commies. Oh, don't forget to plug the fundraiser on the way out. We're not done yet. We're not done yet. Wrestler tells I wish you here earlier when this terrible meditation slander was going down. I was too busy with my tarot cards and my crystals. All right. So, what happened as a result of all of this? Well, let's get back to things here. So, we have the order to conduct the depositions. There was a mailing of a transcript. Cool. There was a letter received from the Journal and Courier. Looks like a newspaper. Don't know what that is yet. But we did get this. Judge Gull is actually granting leave of court to conduct the inmate depositions. I am truly fucking surprised that happened. Considering the last time these guys wanted an inmate brought over, what did Judge Gull do? She blew it up and told the sheriff to blow off the subpoena. Don't worry about it. So I'm surprised. I can see the judge playing fuck games in the next little bit. Or I could see you're giving some sort of fucked up order that the Department of Corrections doesn't recognize or won't follow. Just give it time. Just give it time, chat. There's going to be a rug pull somewhere. Or she'll say, "Great, this is all untimely if you try to introduce it, gone." I think that's what she's going to do at the end of the day. So, Luke says it's a FOIA request for the jury questionnaire. Oh. Hmm. Well, those won't be requests. Well, the jury questionnaire itself, I wonder if they, that if it's a jury questionnaire itself, sure, but all the returned ones they won't be allowed to get. Since the real case will be fought on appeal, how much of this will the appeal court be able to unwind? I don't know. Remember, there is the Supreme Court lamented routinely in its oral argument there was no record. So we don't know what we can only do so much because there was no record. At this point, I think they have to know, and it could probably be the argument could be made at this point because Judge Goals intentionally avoided creating a record and building a record. Now it's an intentional effort by her to avoid creating the record. So good for her. Um, I truly feel sorry for every defendant that comes across her in Fort Wayne, Indiana, and I feel bad for the attorneys that have practiced with this woman because imagine, no matter what you file, denied, denied, denied. You know, the prosecutor's right. They don't indict bad. The prosecutor never messes up. I'm sure is carved into a thing above the door of her chambers. The prosecutor's the good guys, and the good guys are heckin' good. Never met a prosecutor she doesn't like. Otherwise, I don't know what the hell's wrong with this woman because this is truly wrong on so many freaking levels. Here's a fun fact. Harry Potter was a male in the books. Yeah, I thought what I don't get. There's a joke there. That's the same says they could fully reverse. But I don't think they're going to. I don't think they're going to. They could fully reverse this. They could say it's bullshit. But Philip, I mean, are you talking about how much can they figure out? Or they could fully reverse it, they could order a new trial. They could say, you know what? This isn't even close. This shouldn't have been tried. There isn't enough probable, like, this is a verdict that goes against the law. Richard Allen should have been acquitted. He is therefore a free man. Yeah, they could do all that. Is that going to happen? No. Nope. No, 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 no. That's not going to happen. Maybe he gets a new trial out of this, but then we get Judge Gull again. This case will never go to appeal because Allen will be dead before that. Maybe. Judge Gull is a big fan of the Cardassian justice system. Does Judge Gull on C-SPAN so she keep her prank called? Oh, I think so too. I think so too. Access, can the Trump hush money docs be FOIA'd? After everything's over, yeah, but not while it's all going on. So, and that's a shame. You were a lot more optimistic than I, because I don't see anything turning out well by the appellate courts. Can they proffer everything to put it on the record? Yeah, Peter, they can make all kinds of proffers. Whether the judge will allow them time to do it is a whole nother matter. So that's the big problem. Oh my gosh, what do you guys do? Here's a fun fact about Harry Potter. Dumbledore was made gay for J.K. Rowling to score woke points on Twitter. Let them eat her. Well, I thought everybody in Harry Potter was gay. The whole premise of the book. A spell and a counter spell, and ooh, I got my wand. Ooh. Isn't that basically Harry Potter? And then they grab each other's asses on brooms. Like that's what I understood it to be. Who pissed in Judge Gull's Cheerios? Oh, I'm sure she pisses in her own Cheerios. They did a proffer during the hearing on the motion to dismiss. Gull first said no, though. I understand, but I think Peter's saying when it gets to trial, can they make proffers on the record about what they want to show? Sure. The judge could say, no, I'm not allowing you to do it, though. That's the thing. I mean, Judge Gull could say, nope, you're not allowed to do that. I'm not allowing it. But then what do? There's only so much you can do at that point. The jury's sitting right there. You can't make a proffer with them on the in the room. Zaven says, counter spells in Magic the Gathering were completely heterosexual. I will fight you over this. I never played Magic either, dude. I read Lord of the Rings and I'm 40K. That's all that matters. You are ruining my childhood, Sean. Don't make it gay. I got news for you. It was already gay. See, I didn't say I thought it was likely. I was explaining what's possible. Yes. I understand. I agree. I agree. My intro pic looks like I have a wand. Yeah. That's a shame. Says JK ruined it, but it's not canon, so you can ignore it. They don't call it a counterspell in Harry Potter lore. It's called clenching. Are you joking? You're being for real. Lord of the Rings is way gayer than Magic. Really? You're gonna say that? You're gonna say that? Lord of the Ring, like Lord of the Rings is dope. The Jedi are a bunch of pedos. Yes. Well, the Jedi are space ISIS, and ISIS likes little boys. So there you go. BattleTech or get the fuck out. Yeah. Well, BattleTech's not bad. AD says, why is every TV show about Ohio gay? Because they don't want you to feel left out. That's why. So Patty's saying dancing Israelis make the rhythm of our lives happen. Yes. After 9/11, I called it the Twin Towers instead of the Two Towers, and it triggered Lord of the Rings fans. That is awesome. That is awesome. Have I ever read any of the Magic the Gathering books? I didn't know there were Magic the Gathering books. I just thought it was the card game, and I'm like, nope, not doing that. Speaking of gay, Alec Baldwin. Yes, he is very gay. Ken says it was pretty cool they wrote a book to go along with the movie afterwards with The Lord of the Rings. Oh my, the funny part is there are people who probably think that, like, the movie is so good they wrote a book. Um, Lord of the Rings is a phone book read about some dude taking a walk for 3 months when they could have flown there in an hour. Yes. Yes. Yes, that's the thing. Why didn't they ride on a fucking eagle the whole way? Gandalf could have got a hold of him. Have I seen the Clerks 2 Lord of the Rings, Larry? No. The 3 movies about people walking, even the trees walk. The only people that don't walk are the eagles. Gene Williams says, "What is a proffer?" A proffer is where you're in court and you lay out on the record, and you do this outside the presence of a jury, but you tell the judge, "Judge, I want to offer this witness or offer this evidence. This evidence is going to show X, Y, and Z. And because I want to show X, Y, and Z, here's why X, Y, and Z is important and relevant. And here, what will that do for the case?" So they could say, "Your Honor, we want to introduce this video," and the judge could say no, and say, "Your Honor, can we?" The state objects, and the judge agrees. You can ask the jury to leave the room, and you can make a proffer on the record saying, "Your Honor, this evidence will show X, Y, and Z. Here's what was going to show and happen. Here's how it will help Richard Allen." The state can do it, and they can make proffers to things. It also gives the judge a chance to hear it. Then maybe they change their mind. But more importantly, the proffer is meant for the appellate court to take a look at it, and they could say, "Okay, now you've made it clear what was going on," because otherwise, if you don't make a proffer, the appellate court has no idea what you were intending to offer or what your um, arguments against the objection were, so they can't comment on it. You always have to do a proffer to say what your evidence was going to do, because otherwise the appellate court can't assume what you were talking about. Even if that same attorney wrote the appeal, none of it's written down in the transcript at that point. And remember, if it's not in the transcript, it never happened. The only time that's probably different is if it's in other parts of the court record. Zoomers don't even know what books are, yeah. Is Carrie? We're gonna do Carrie Morrissey's thing soon. We might get to that tomorrow afternoon if we get the rest of the trial caught up. Why didn't the Eagles fly them? Why, Sean? I don't know. I don't know. God damn it, Sean. That was explained by Tolkien before he died. Yeah, well. Then like Lord of the Rings because they stole my feet pics. Yeah, well, I have Hobbit feet, so that's a problem. Lord of the Rings is European history, pretty much. Pretty much European history. Philip says, "What I meant by unwind is how much stuff can the appeals court stop from coming in during a second trial, and how much stuff has been screwed unfixably?" Well, they can't really do anything about that. If they order a new trial, then all that stuff has to get relitigated. All this would have to get relitigated. Thankfully, the defense knows about everything now. Hopefully, they can at least say, "Look, Judge, we have all this stuff. Here's our motions to eliminate, motions to suppress, motions to strike evidence, blah 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 blah." And they would have to redo all of that, because you don't get to generally you don't get to come back. The only times you don't the only times things get done like that are like if there's a motion to suppress and then the person enters a plea, but they're allowed to pursue the motion to suppress. And that goes up to the appellate court. The appellate court says, "Yeah, the motion to suppress was bad. Like, the motion to suppress was good. The evidence is bad. It shouldn't be allowed in." And it comes back down to the trial court. Well, then you start there with the appellate court saying, "Okay, that evidence is bad. It's gone." But for the most part, if he gets a new trial, you have to kind of start all over and reinvent the wheel. Is generally how that's going to go. Because the Eagles had things to do. You try to order on a 15-foot raptor. I'm just mad Harry Potter BTFO Lord of the Rings about the books and movies with the epic lore. You're a wizard, Harry. I'm what? That's all the lore I know about Harry Potter. And then there's the part where they're flying in a car and apparently there's a flying train chasing them. Although they're in a flying car, why can't they go like "Whoop"? Because like all I know about that is the Thomas Tank Engine meme. Eagles showed up when things were dire. They are not a taxi service. Well, the whole thing's fucking dire. Like the bad guys are on the move. No. I only get they're like I only flap my wings when it's like right at the end. You know, they're only the Eagles only get up when it's game 7, not game 1. You could have won it during game 1, but nah. We're gonna wait till like 2 minutes left in game 7, then we'll show up. Jerax says, no offense, who is fatter, you, EVS, or PPP? Probably PPP. I mean, I bet I'm fatter in EVS. Thanks for asking. The Eagles were on tour at the time. Hey, you know, they were putting out some they got some banger fucking albums. You know, they were getting over the loss of Don Henley leaving them, so they spent a lot of time being quiet. Pay says there were no Eagles in the books. Well, it's because they weren't flying, they were being lazy. Eagles live like they have a gambling addiction. J-Rock says, I'm sorry, I'll explain why I asked later. Because we're all fat. I don't know what to tell you. Who likes pie the most? I can't be Pie Man. Pie Man is Pie Man. Pie Man likes pie. AD says, is it true judges conduct voir dire in federal court? Pretty much, yeah. Yep. Federal court judges do it. There are some courts where judges do a lot of the jury, do a lot of the voir dire. Generally, though, at the state level, it's up to the attorneys to do it. So. Ken says, how does one file a motion to oppress? I've never heard about that one. Well, a motion to oppress is known as an indictment. So the state files those all the time. They oppress people with those. Did I just stop myself from saying I can't out-eat Pie Man? No. What is a hairy pie? I'm a pumpkin pie man myself. Gandalf is a pothead with dementia, and the hobbits all have eating disorders. Well, they might be the hobbits might be scarf and barf when they talk about like, oh, we need second breakfast. Well, I'm the first breakfast. It's like we barfed it up. They're always on purge mode. They're binge and purge like from hour to hour. It's binge and purge. Ken says based. So. Oh. But yeah, that's a shame. I need to reach out to you and Kara again. I have some questions and I don't know the answers to them for this because yeah, this is getting crazy. So, guys, yeah, that's it. It's sobering to see how a man's being treated, but never. 80 says, what is harmless error? Harmless error is when, sure, the prosecutor messed up or the judge messed up, and it was a big mistake. It was a big mistake. But if even with that mistake there, everything else, even remove that mistake, Richard Allen's still guilty. And you'd like to think, wait, is that really how they do this? Yes. That's a way of them. That's a way the Court of Appeals will just punt and kick out an issue and kick out something that's wrong, they don't have to worry about it then. Why? Because they punted. So it's sobering, but that's what it is. It's a thing courts have developed to avoid having to relitigate cases. So guys, tomorrow at noon, we will start up George Kelly, finish him up, and then if we have time, we will do Alec Baldwin tomorrow night. If we don't have time, we won't get to it. If not, we'll get to it like Tuesday or something. Ian's definition of harmless error is any effort that benefits the state, pretty much, or the court. Remember, the court is government, and the government will protect government at the end of the day. You missed a whole stream due to boring UFC 300. You really, who thought that was going to be a good UFC? It's going to be horrible. So, good night, everybody. I will see you tomorrow. And yes, Richard Allen is not guilty, even though the state is completely fucking him over. And remember, to Israel and Iran out there, I just want to remember, I want everybody to have fun. That's what matters most. Good night, everybody.